Bon matin, tout le monde.
Good morning, everyone. Welcome.
Welcome to meeting 101 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on February 14, 2024, the committee's meeting in public to begin its study of Bill C-273, an act to amend the Criminal Code, Corinne's Quest, and the Protection of Children. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23, 2022. Members are attending in person in the room and remotely using the Zoom application. Members using Zoom already know, so I will not go through the process of how you're supposed to use Zoom, and I believe all our witnesses are appearing in person for the first panel. Alors, je voudrais remercier.
And so I'd like to thank the witnesses for appearing today. We have with us today the Canadian Teachers Federation, Heidi Yetman, President, and Tessa Fidler, member of the Advisory Committee on Indigenous Education. We then have with us the Quebec Provincial Association of Teachers, represented by Mr. Sébastien Joly, Executive Director. Welcome. You will have 5 minutes for your opening remarks, and this will be followed by members' questions. So we are going to begin.
Thank you, Chair. I'm pleased to be speaking today as a representative of the Canadian Teachers Federation, an organization comprised of teachers' unions in every province and territory. I am a teacher with over 20 years of experience in the classroom. I would like to acknowledge that I work and play on the unceded territory of the Algonquin Anishinaabe people. As you know, I'm here to talk about Bill C-273, a bill that seeks to repeal Section 43 of the Criminal Code. With this, I need to state first and foremost that the Federation fully endorses all TRC calls to action, including action number 6. We also fully condemn any form of corporal punishment. That being said, the Federation cannot support this legislation passing unamended. The risk of unintended consequences that could make classrooms more unsafe is too great. Teachers need to be able to physically intervene in certain classroom situations. This is the reality of dealing with complex classrooms with complex needs. And I'm sharing my time today with teacher colleague Tessa Fidler. Tessa is a member of the Federation's Advisory Committee on Indigenous Education, and she's also a member of Education's International Indigenous Reference Group. So I'm really pleased to present Tessa.
Miigwech, Heidi. Thank you. No, that's good. Thank you. I forgot that step. So, Tessa Fidler, Indigenous. I am a First Nations educator, registered to Kichinemegazib and Inuag in Treaty 9. I'm also connected through my father to the traditional territory of Onigaming First Nation in Treaty 3. My family and I have lived and worked in Thunder Bay, Ontario for the last 26 years, and we raise our family there. So first, I as well would like to acknowledge that I'm grateful to the Anishinaabe and Algonquin people whose land I'm visiting here for being caretakers of this territory since time immemorial, for allowing us to do this work here. As an Indigenous educator with close to 30 years, I couldn't believe that when I read that, I'm like 30 years of experience, and as someone who is deeply committed to supporting the act of reconciliation, I'm here to speak about the necessity of amending Bill C-273. I want to assure the committee and other individuals who are committed to repealing Section 43 that I also recognize the significance and the importance of making this important change to the criminal code. I personally honor and respect the calls to action. As a second-generation survivor of residential school, my mother attended Poplar Hill and my father attended Cecilia Jeffrey. The calls to action have significance to me both personally and professionally. As a witness to violence myself, I would never condone any form of violence in homes, classrooms, or other institutions. I have the utmost of respect for Honorable Sinclair and the many individuals who courageously led the TRC and provided this country a guide to improving relations between Indigenous and non-Indigenous peoples. I am not here to disagree with the repeal of Section 43. I am here to request that you consider the suggestions that teaching experts bring forward, suggestions that will continue to protect students and their educators. Over my career, I've worked with students who have complex needs, and I've been a mentor to many teachers and educators who deal with complex classroom issues. We have students with autism and FASD, students with problems regulating temper, students with histories of violence and exposure to trauma. In an ideal world, there would be more support for students in difficult situations, and educators would get the support we need to deal with these complex student profiles and situations in classroom. The sad reality is it is not there. So passing Bill C-273 without an amendment will make an already challenging job more challenging. These are the realities that all educators, but also Indigenous educators, are facing. We have very complex community situations right now. We are in crisis with our, well-being of our children. And as a parent of a child with complex special needs, I recognize the challenges that our communities and our families are facing. And it really is a disadvantage to children, to educators, to put this bill, or to repeal this act and not be making the amendments and suggestions that are needed to protect children.
Thank you very much
Thank you.
for your opening remarks. We will now go with Monsieur le Directeur Général.
Merci.
Thank you very much. My name is Sébastien Joly, Director of the Quebec Provincial Association of Teachers. We represent the 8,000 teachers who work in Quebec's English language public system. The QPAT is also a member of the Canadian Teachers Federation and negotiates in cartel with the Fédération des syndicats de l'enseignement du Québec. I'd like to begin by thanking you, the members of the committee, for allowing me to present Quebec's perspective and the reality of the teachers we represent in the context of the study of Bill C-273, which deals with the repeal of Section 43 of the Canadian Criminal Code. From the outset, the repeal of Section 43 without amendment is a major source of concern for our association. Knowing that this bill stems from the 94 recommendations of the Truth and Reconciliation Commission and the related calls to action, it is essential for me to clarify that the position adopted by the QPAT is in no way intended to minimize the abuse suffered over years by the Indigenous peoples of Canada in residential schools, nor to question the highly symbolic value of the removal of Section 43 of the Canadian Criminal Code, a symbol of the past practice of corporal punishment, both in educational institutions and households. To the contrary, the Association fully subscribes to the spirit of the measures recommended by the Commission and has been actively involved, in particular, in the curriculum review process in connection with calls to Action 62 and 63, Education for Reconciliation, that led to the review of the content of the History and Citizenship Education program in Quebec. Furthermore, the QPAT has been opposed to any corporal punishment. I'm now going to switch into English.
While we are fully aware of the intent behind the introduction of this bill, it is essential to ensure that its adoption does not result in unintended and unfortunate consequences for the teachers we represent. In this sense, we are convinced, following the advice of our legal experts, that the removal of the elements of protection included in Section 43, in the absence of an amendment to the Criminal Code to guarantee protections for school staff, would constitute a serious risk for teachers as well as for other categories of school staff, particularly given the context and conditions in which they practice their profession on a daily basis. Indeed, the increasingly heavy and complex composition of the classrooms in the context of glaring lack of professional and specialized support resources, as well as the constant progression of violence in our schools, whether in or out of class, means that teachers are confronted on a regular basis with situations that could require the use of reasonable force towards a student with the sole objective of fulfilling their responsibility to ensure a safe school environment for the students. The legal vacuum thus created would necessarily expose them to an increased risk of criminal charges, prosecution, or even convictions for interventions carried out in the course of their duties. These interventions would automatically be considered assault under Section 265.1 of the Canadian Criminal Code. As Executive Director of QPAT, I am directly responsible for following up on all cases related to criminal allegations filed against teachers who are members of our local unions throughout Quebec, working closely with the law firm Batista Turco Israel from Montreal, who represent our members in such cases. As such, I can confirm that the existence of Section 43, the scope of which was significantly redefined by the 2004 Supreme Court's decision, can no longer be used as a defense for teachers charged with assault within the meaning of the law. Nevertheless, I can confirm that it is the very existence of Section 43 that allows the various stakeholders involved, police investigators, prosecutors, judges, to exercise a certain level of discretion in such cases, particularly when it is clear, following investigation, that an educator used reasonable force with the purpose of ensuring safe school environment for their students. As a result, many cases do not proceed to trial. According to our legal experts, the complete repeal of Article 43 would result in the disappearance of this level of discretion and in an increase in the number of charges, prosecutions, and convictions, with all the impacts that this implies for the individuals concerned and their families. Finally, we are also concerned that this increased risk for teachers could cause additional unfortunate and unintended consequences, including making our schools less safe, but also discouraging potential future teachers from choosing this beautiful profession and making a career out of it, thereby further exacerbating the teacher recruitment and retention crisis facing our public school systems in Quebec and across the country. It will be my pleasure to answer any questions you might have and develop more on the elements presented in the brief submitted by QPAT. Thank you. Merci.
Merci à vous. Merci beaucoup.
Thank you. Thank you very much. We are going to begin a first round.
We'll go to Mr. Frank Caputo.
Thank you very much. I want to thank all the witnesses for being here. It's a pleasure and honor to be with you, in part because I have a child who is neurodiverse, and my sisters are both teachers, and I practiced and taught criminal law for a number of years, so it feels like the intersection of those three things coming together. So I thank you for the discussion and for your presence here. I think that goes without saying that everybody here, including the panel, denounces any form of abuse. The question is how should the law properly respond to what is necessary, I suppose I could be using your words, for a safe school environment. And that's where I take your positions. Now, in your opening statements, you didn't really get into we got into the broad strokes, so I'm not sure if on behalf of both organizations, if you could point specifically to the frailties of the removal of Section 43, what would those be from your experience, please?
Want me to start?
Both organizations.
So, as I said in my opening statement, I've taught for over 20 years, 23 years, and I remember my first job, I was in a pré-secondaire, which is a grade 7 class. I was brand new. You know, when you're a new teacher, you do your best. And a fight broke out in my class. Luckily, they were smaller than me. They were in grade 7, they were 12 years old. And it was quite the fight because there was blood drawn. And I pulled those two children apart. And one I took with me to the principal's office. According to the criminal code, that could be assault. And of course, I did my duty because I wanted to protect the kids that were in the fight, and I wanted to protect the children that were in the class. I could have been charged with assault for doing what I did. I didn't know. I was new. I didn't even hear of Section 43. So this is our fear, is that by not amending Section 43, we put teachers at risk of being charged with assault. In our brief, there's about 50 examples of incidences where Section 43 was called upon, and they didn't go to court, those cases. Some of them did. There's one recently in 2023, Bender versus Ontario, that went to court, and that teacher was dismissed. But this is what we fear. And another thing that we fear is, personally, as a union leader, I would be telling teachers, be very careful. Do not put your hands on children. There is nothing to protect you in the criminal law.
If I may add, essentially to your question, we in Quebec have the same concerns regarding the repeal of Section 43. With our experience in Quebec and the experience of the Quebec Provincial Association of Teachers regarding allegations of criminal nature that were filed over the years against teachers, and it has been confirmed by our legal counsel we work with on all those cases, that Section 43, although, because we've been asked how many cases have been, or how many court decisions have been mentioning Section 43 as a defense for a teacher or an education worker, there's not that many. And because there's a reason for that, the majority of cases do not go to trial. I was a witness to one case where we went to trial. We were before the judge representing our member, and the judge from the get-go, I think it was a junior prosecutor who probably was not really aware of the existence of Section 43, and basically the judge right away took a decision on the bench. It's not documented, because he was actually reminding the prosecutor of the existence of Section 43. So it's very important to understand that probably 90 to 95% of the cases where there are allegations, Section 43 is considered by the different stakeholders before it goes to trial. And obviously, from experience too, there are allegations on a regular basis towards teachers for various reasons, including assault or alleged assault. And it takes a big toll on these teachers and their families. Even for investigation to be completed, often of time we're looking at 1 to 1.5 years, before the investigation is completed, and that's even before the prosecutor is looking at the case. So the teachers are suspended for a good amount of time, and certainly we have exactly the same concerns that we will multiply the number of allegations and accusations, and maybe more cases going to trial in the absence of Section 43.
Thank you. I appreciate your time, because I know we probably don't have time to go through a lot more here, but to me, a teacher, and I'm thinking about my own child too, and needs that arise in order to protect them and protect others in those situations. I mean, the situation mentioned by Ms. Yetman there, to separate people, to me, it's an unfortunate part of the job. I don't think anybody wakes up in the morning, a teacher wakes up in the morning saying, I want to do this, but I take your point, assault is a non-consensual touch, and no one's saying, please touch me there. So,
Merci. Thank you.
Thank you.
We will now move on to Mr. Housefather.
Thank you, Madam Chair, and thank you so much to Ms. Yetman and Mr. Joly, and both of your organizations are very important to me. My mom was a school administrator. Both of my aunts were school administrators. So I've heard directly several times about the consequences of this bill and what they think about it. Can I ask one question, Mr. Joly? You made a very good point, because there's been a lot of people that have raised, well, there's so few times that this needs to be used as a defense. What you're actually saying is that it's rarely needed to be used as a defense because prosecutors know that it's there and therefore are not charging people with allegations related to assault in the classroom. Would that be correct?
That's exactly what I was saying, because, again, I've been handling those cases since 2016, but the firm we're working with has been working with the association for more than 20 years. And certainly there was a big change since the 2004 Supreme Court decision that really, limited the scope or realigned the scope of Section 43. And certainly, in most cases, it doesn't go to trial. The charges are not deposited because of the existence of Section 43 as realigned by the 2004 Supreme Court decision. And again, in an ideal world, it would be possible for teachers not to intervene ever physically towards students who would have enough support staff and resources in order to deal with all situations. But in my brief, it's very clear, that statistics we have about violence in the classroom and the number of possible situations that teachers are faced with on a daily basis, particularly those who are teaching in specialized settings, we're talking daily. So obviously, it would be a big loss if there's no amendment to really provide protections for our teachers and education workers.
No, and I appreciate that. And I have one more question before I go to Ms. Yetman, Mr. Joly. One of the claims that has been made is that there are other professions that deal with children, a nurse's aide, a child care worker, that are not covered by this defense, and yet somehow there's not an extraordinary number of charges against them. Could you explain why you believe there needs to be a specific category protection for teachers?
Essentially, if you read my brief, you will see that I'm talking about education workers, also school staff, because we're representing teachers, we're representing people who work in the education system, so we're not representing nurses. But in essence, the number of cases compared to the number of workers who work in the school system is not that great, but every single case, as far as we're concerned, counts. And we have enough per year just for the 8,000 teachers we represent, whereby Section 43 and the elements of protection included in that are considered to avoid these charges to being pressed against teachers for actually applying a reasonable force in a context where they're trying to ensure a safe school environment for their students.
Thank you. And Ms. Yetman, we had a chance to talk about this, and I like the example that you gave of your grade 7 class when you first started teaching. Can I ask you, as I understand it, your organization is not opposed to the repeal of Section 43. You simply want it to be replaced by a modified defense that would be more in line with contemporary values, correct?
Well, of course, Section 43, I think, was written in 1892, so we do need to update that. Of course, the 2004 Supreme Court decision was very helpful in adding guidelines. We believe in truth and reconciliation. We actually think that it's a shame that only 13 of those actions have happened so far out of 94. And so, yes, I think that it needs to be revised. It is too vague. It's not clear. And that's why we're suggesting an amendment. And the amendment would be called like a safe school amendment, really focusing in on safety.
100%. And can I ask, would you, and I've seen the amendment and I support the variation of this amendment, would you object if, for example, other professions that also dealt with children in a similar way were incorporated into the same wording that you proposed? For example, child care workers, nurses' aides, etc.?
Now I'm speaking personally. I don't see a problem with that. I, of course, am representing teachers and education workers, so I wouldn't want to speak on their behalf. But I think we need to protect people that are working with children, that are doing things to keep them safe. That's what it's all about. It's about keeping children safe.
And making sure that there's not a teacher or other educator that wouldn't act in a situation where they needed to pull children apart like you did. Okay, thank you so much, Madam Chair. I see your hand is up. Thank you.
No, you have 20 seconds left.
Well, anyways, I want to just thank the witnesses for
Well,
being here. I
thank
highly
you.
respect the organizations. Thank you.
Thank you very much. Alors, on passe maintenant.
We'll now move on to Mr. Fortin. Thank you very much, Madam Chair. I'll use those extra 20 seconds if you don't mind. Ms. Fiddler, Ms. Yetman, and Mr. Joly, thank you very much for coming today. Now, I don't know if it was said at the beginning, but as you know, we do have interpretation services, so you can answer in the language of your choice, and we will all understand your testimony. So I'll leave that up to you. Now, I'm very happy to see you here today. This is a very important issue. It deals with our children and their safety and their education. And obviously, any violence towards children must be prevented. And as lawmakers, we have to make sure that violence is never authorized. Now, if we sort of look at the overview of the jurisprudence and what's happening in other areas, what strikes me is that corporal punishment is forbidden pretty much everywhere. But I'm wondering here if we're not mixing up a few things here, corporal punishment and the use of force in order to ensure the safety of our children and their education. That is to say, to protect them and to protect their environment, whether it has to do with classmates or other people. So this is the concern I have here when we're talking about C-273. I've been very interested in hearing what you have to say, because it kind of runs along the lines of what I've been thinking since the very beginning. But I would like to hear you on this. Mr. Housefather said, could it not be useful to provide an exception for other people, health workers, for example, working with children? So how far should we go? Should we sort of put some of these workers on an equal footing and make these changes? In other words, anyone who has the authority of a parent or delegated authority, for example, whether that be a teacher, another parent, for example, do you think these should be included? So could you just expand on that, perhaps Monsieur Joly first and then the others? Well, once again, I am a parent as well. So as a parent and also as the representative of teachers, I would say that I'm speaking on behalf of these teachers and other educational workers. Mr. Housefather was asking if we could include, for example, all people who are involved with children, whether it be educators or whether it be in daycares or elsewhere. We wouldn't be opposed to that. However, what we're talking about today is the teachers and the teaching environment and our concerns about the consequences of a repeal without amendment of Section 43. Consequences on their daily work and on their exposure to potential problems because of the work environment, because they are already exposed to these issues. And what about parents? Well, as I said, as a parent, I could say, personally, I wouldn't oppose that. Obviously, there are groups of parents who will be able to speak to you. But I would say, personally, that sounds reasonable to me to include parents. However, once again, I do represent the teachers here today. So I'm just trying to be diplomatic here. Thank you very much, Mr. Joly. Ms. Yetman. Well, I'll probably answer along the same veins. I also am a parent of 2 boys, and I remember at times I've had to make them put on their boots and hold them to make them do that. So personally, I wouldn't say that I would be opposed to an amendment that could help the public in general, including parents. However, today I am here on behalf of teachers, and so I have to be the voice of teachers today. Thank you very much. You're all doing that very well. However, I'm asking you the question because you are the experts, in a way, on education, the education of children, and this is going to impact all those who are involved in the area of education, whether it be those who are looking after them or those who are teaching them. So all these people who are involved in children, and so should they not all be treated in the same way? And should we not ensure that all those can intervene when they need to, when they are responsible for these children in one form or another? I don't know how much time I have left. Time goes by very quickly, but I'd just like to raise something else quickly. Bill 273 actually stems from or is aligned with the calls for action under the Truth and Reconciliation Committee. You mentioned it yourself. And I'd like to know if you have an opinion, perhaps you don't, but if you'd like to have an opinion on how the repeal of Section 43 from the Criminal Code would help advance the issues that Indigenous communities are dealing with. Now, we know that there has been abuse in the past. None of us find that unacceptable. But what would the repeal of Section 43 do to advance Indigenous communities in this country?
The repeal of Section 43 would just honor, I think, the history, honor the history and the truth that came out of the history, and that history has caused a legacy of ongoing violence and harm. And so those were the recommendations that came out of that. Now, we could probably go back now to community. This is, 8 years later, and start asking, what do we need next? And that is to put in those safeguards that will protect children and families and the organizations that are providing a service to a very vulnerable population. So I think that is what the repeal would do for our communities.
Merci à vous trois.
Thank you, Gretch.
Thank you to all three of you.
Pour le record, j'ai
Just for the record, I did give you more than 20 seconds extra.
on passe for
We're now going to move on to Mr.
6 minutes.
Thank you very much, Madam Chair, and I thank the witnesses for being here today. And I do recognize that you're doing a job of representing your members, but I have some questions which are not hostile, but I have some concerns. And I guess I'll talk about the 94 calls to action. Were either of your organizations involved with the Truth and Reconciliation Commission at the time of the hearings?
I have only been present since July of 2023, but we work very closely with our advisory committee. So, and I don't know if Tisa, you were involved at that time, so I really can't answer that.
We were not involved in an association in the commission, in the workings of the commission, but we did take steps even before the end of the work done by the commission since early 2000s in order to push the government Quebec to review education programs, namely history programs. I'm a history teacher. As a union representative, I've been pushing that for quite a while with, some success. Not perfect, but certainly there were changes made in the content on the Action 62 and 63 particularly. We were involved actively.
And if I'm not mistaken, I believe both your organizations did endorse the calls to action at some point.
Yeah, that is correct. And we have done a lot of work in trying to get the calls to action for education moved forward in the provinces.
Sorry if I could just answer. So I've been with the Canadian Teachers Federation on the Advisory Committee for Indigenous Education. This is my 5th year with the organization, and I worked provincially with the Ontario English Catholic Teachers Association for about 8 years, I guess 7 years. It was shortly after the calls to action were published. I've been part of the revisions to the Ontario curriculum. I've been on the writing teams. But personally, I gave testimony at the Truth and Reconciliation Commission. I've worked very closely with many folks that have been part of the TRC. My husband worked with the Truth and Reconciliation Commission and traveled across the country. So the advisory committee brings that depth of knowledge and guidance to the work of the Canadian Teachers Federation.
And I'm asking that question to both of you because I think there's both a real substantive problem and a perceptual problem if non-Indigenous organizations are substituting their judgment for the Indigenous community on this section. So what I was trying to do is give you a chance to express your support. Has there been any communication with Murray Sinclair or the other commissioners about these concerns with the repeal of this section?
Well, I do know that the Canadian Teachers Federation did meet with Sinclair. This was before my time, and we have spoken to him about this particular action.
Because
number
I do
6.
think that's an important part of the reconciliation process,
Yes.
is to continue that dialogue. Mr. Joly.
And I've been part of meetings back in 2018 with a group of senators that had taken on, this action, basically, and to raise the same concerns. Met with 5 senators at the time, and then it fell on the wayside, and then it's picked up again. But certainly, we express the same concerns with the complete repeal of 43 without any amendments.
Go ahead.
Sorry. Just to renew the new term of this committee for the Indigenous Advisory. We've reached out to reestablish and to maintain relationship with the National Center for Truth and Reconciliation as well. With COVID, there was the pause, but we're actively doing that work to engage the NCTR and continue supporting the good work and important work they do.
Thank you for anticipating my next question. We have some other technical problems, I think, given that we're dealing with a private member's bill before us. So I do not in any way doubt the challenges that teachers are facing in the classroom at this time. And I'm not at all one to diminish the concerns about the legal consequences of the repeal. But 2 things I would raise here. One is that education is primarily a provincial jurisdiction, and therefore I'm not sure outside the criminal code we can deal with some of the major problems. And the second is, of course, that this bill deals with repeal, and private members' bills have a certain scope by the rules of the House, and trying to amend either other sections of criminal code or other acts may be difficult and may, in fact, be out of order. And I just wonder if you have any reaction to those concerns.
Well, from when we consulted our legal counsel, certainly this issue was raised, the technical issue of how do you bring about an amendment. And from our understanding, and maybe we're wrong, but from our understanding, it would be possible that the committee increases the scope of the bill. And if not, is it possible to actually make an amendment to the criminal code at a different time? But again, it would be ideal for us that it would be attached to this bill, that there would be a guarantee of ensuring protections for education workers and teachers within the bill.
Yes, and of course, I'm a teacher. I'm not a legal...
Time's up, but I would like to hear the answer
I'm not a
to that.
legal connoisseur, and I don't know the procedures in legislation, but we are counting on all of you here in the room to help us with that so that we can make sure that students are safe in classes.
Thank you very much. We will now go to our second round, and for 5 minutes to Marilyn Gladue.
Thank you, Chair, and thank you to the witnesses for being here. I come from a family of teachers. My mother was a teacher, and my daughter teaches now on Six Nations. So I'm very happy to hear your comments today. One of the discussions that we've had in the testimonies we've heard so far is that we've clarified that it's already illegal to abuse a child or to do violence to a child. And certainly, I think the Supreme Court decision, as Mr. Joly mentioned, with their interpretation, they added that the use of force must be sober and reasoned, address actual behavior, and be intended to restrain, control, or express symbolic disapproval. They also noted the child must have the capacity to understand and benefit from the correction, which means Section 43 doesn't justify force against children under the age of 2 or those with certain disabilities. And according to the decision, reasonableness further implies that force may not be administered to teenagers, as this can induce aggressive or antisocial behavior. And moreover, force may not involve objects such as rulers or belts and may not be applied to the head. So I think that, we've heard from you today that There are not that many complaints being brought forward, and because people understand the protections under Section 43. And so my question then is, do you think that Section 43 as written does provide you needed protection today? We'll start with Mr. Joly.
Yes, it does, as written, but also as realigned or modified with the Supreme Court decision from 2004. And it is the opinion of our legal expert that if it's repealed completely without any amendment or any form, like, again, technically, I don't know how to do this, but maybe you know, but it would pose a risk, and it would change the game when it comes to these kinds of allegations. And again, when I was saying that Section 43 is always considered by stakeholders who are involved, investigators and whatnot, and it's always after the investigation has been completed and the conclusion of the investigation shows that, you know, it was used a reasonable force as per the definition, and also it was meant to provide protections or to ensure safety in the school environment. And that's where the stakeholders can use their discretion. That's where the police usually will say to the prosecutor, we would not recommend that you proceed with charges. The prosecutor will move ahead with this and not proceed with charges. And that's where it has an impact in 95% of the cases.
Thank you. And same question, Ms. Yetman.
Yes, right now it is protecting teachers. There was a judgment in December 20, 2023, the Ontario Court versus Bender, an elementary teacher who was teaching grade 3. He was teaching a difficult class of students with special needs, and the conclusion was that unfortunately, what happened was he was charged in December of 2020. It took 3 years before the judgment came out, and the conclusion was his actions were justified under Section 43. So yes, it is doing the job. Now, as I said before, it was written in 1892, and I think the problem with Section 43 is force by way of correction. And that's why our amendment is really precise about safety.
Further to that, I think Mr. Garrison is actually correct that we're not allowed to expand the scope of the private members bill. And with that in mind, then to me, keeping 43 as it is, and knowing that the courts are going to interpret not just Section 43, but also the Supreme Court's judgment upon that is going to be important. Now, is there anything else that you would like to tell us in terms of expanding this, the scope of who it covers? I know we've heard Mr. Housefather on including other people. I heard you clearly say parents, teachers, but you're not opposed. Is that fair? Mr. Joly.
Again, we're representing teachers.
All right, and the same comment from Ms. Yetman. Okay, thank you so much for your answers.
Thank you very much. We will now move to Madame Dillon for 5 minutes, s'il vous plaît.
Thank you to our witnesses for being here and the important work you're doing. I'd like to start with, a comment. Section 43 doesn't apply currently to nurses, childcare workers, or other professionals who deal with children regularly, and they may need to use force to ensure a child's safety. These individuals are not disproportionately sued for using force. We're talking about reasonable versus unreasonable force. Why do you expect that teachers and parents are going to be unfairly treated if these other professionals are not? Thank you.
Okay. So first of all, since the pandemic, I think it's really important to note that violence in the classroom has gone up. The Elementary Teachers Federation did a member survey in 2023, a year ago, and 80% of their members said that the number of violent incidents has increased. And teachers will experience an upward of 50 instances of harassment or violence over the course of 1 year. So, and I also want to just mention, which may not might be a little bit outside, widening up about a bit. 80% of teachers are women. And I think that's important as well, because it means that women are working in very unsafe environments. And what we're seeing, because as Tisa mentioned, we don't have the resources, there's systemic underfunding of education in provinces. We need more training, we need more resources, and since that doesn't exist, if Section 43 disappears, we're going to see, as we've said before, we're going to see more problems of violence because teachers will be reminded to not put their hands on children. So we're going to do more of these evacuations. I'm sure you've heard of these, where a child is having dysregulation and we have to evacuate the entire class.
Well, as my colleague, Mr. Garrison, has pointed out, this part really falls under provincial jurisdiction. We're talking here about protecting children from unreasonable force. I'm very concerned as well in daycares. Children of 2, 3, 4 years old cannot express themselves, and they are subjected to abuse, a pinch on the upper arm, a tug to the hair, and things like that. And it comes in the news, and it's sometimes horrific stories. How do we protect those children who are not able to express themselves? If you can please elaborate on that. And how come, there should be an exception in the criminal code for the use of force to correct children's behavior when we don't have such an exemption for any other class of people?
Again, the exception or the amendment we're asking for is for the sole purpose of ensuring safety, a safe environment in a school setting. It's not to allow teachers to use force to correct students. And by the way, Section 43 no longer, if there's a situation where unjustifiably and not to ensure safety, a teacher or an education worker, educator in a daycare center would use force to correct a student, it's unlikely that Section 43 would protect them currently with the 2004 realignment by the Supreme Court decision. So essentially what we're demanding about the amendment is really to ensure that those protections for the safety of the school students be maintained or be placed somewhere else in the criminal code, because in the absence of this, and it's our legal experts' opinion that we should advise our members not to get involved physically under any circumstances, because of the risk of possible allegations and charges.
And as our witness, Ms. Yetman, has pointed out, most teachers are female. My mother was a teacher. Her 4 sisters were teachers, and so I come from a family of educators. And if you can quickly tell us what other tools could be available to protect these female teachers, other than having to change this legislation, which is really the aim to protect children. Thank you so much.
Yeah.
This is going to sound crazy, but we need resources. Well, it's not that crazy, actually. It's been years and years that our school systems have been underfunded.
So I'm going to have to interrupt now just to allow the 2 remaining to answer questions. Alors, Monsieur Fortin, pour 2 minutes et demie, s'il vous plaît.
Mr. Fortin, you have 2.5 minutes. Thank you very much, Madam Chair. Now, we've heard that repealing Section 43 could potentially lead in an increase in the number of charges brought against teachers. Our committee has heard testimony on provisions of the criminal code that deal with underrepresented groups in our society. And I'm wondering what effect there would be on other underrepresented groups if Section 43 were to be repealed. Let's say, for example, Indigenous parents, or whether it be racialized parents or parents of racialized children. Would repealing Section 43 have an impact on those groups? And if so, what would that impact be? Well, I'm not sure that I'm able to answer that question, but the protections under Section 43 also apply to parents. Now, I only have 2 minutes, so if you don't actually know, then perhaps we'll move on to Ms. Yetman or Ms. Fiddler.
Yes, so just the impact that it would have on underrepresented groups. So I can speak as an Anishinaabe person, and what I've witnessed and what I've experienced as well. And there is a lot of, because of the history and the trauma that we've experienced, there's been a lot of family and community breakdown, and the systems that have traditionally been in place no longer exist. And so there's a lot of intergenerational parenting that is happening. Example, my mother is raising her great-granddaughter, her 9-year-old great-granddaughter, because my nieces are struggling with their own mental health and addiction issues. And so when there is that intergenerational parenting happening and biological parents might be absent, there is right there the optics of what is considered healthy parenting or healthy family systems. And, those are determined. We think about child welfare, what is an imminent risk. Those have been created by Western systems. So even though we are doing our best to maintain and preserve family, it isn't happening. But we're doing the best we can. We know that we're only 4% of the population, Anishinaabe or Indigenous people in Canada, but 30 to 50% of our jails are Indigenous people. It's disproportionate, incredibly, and we could say the same for Black people as well. Very disproportionate in its ratio, and so it would definitely have negative consequences.
Thank you. Merci beaucoup.
Merci.
For the last 2.5 minutes to Mr. Garrison, please.
Thank you very much, Madam Chair. So in the spirit of getting to yes and making sure there's no misunderstanding, I've listened carefully to what you had to say, and I believe both your organizations are saying that, in fact, you do support repeal of the existing provision, but that you need additional protections for teachers. Is that going to happen? Is that correct?
Absolutely.
Okay, so then that presents us with a challenge as a committee. And I appreciate that you've made suggestions for those changes that need to be added. And I remain concerned, as Ms. Gladue pointed out, we can't actually expand scope in a committee. Only the House can do that. And it's very rare that it happens. However, there are some ways in which we could get to the amendment. One is, of course, the government can at any time introduce legislation. So if this private member is moving forward, the government could introduce companion legislation that would make the changes that you're talking about, or another member could introduce an additional private member's bill, although that process is, of course, longer. So maybe I'll just, as we're running out of time, I don't believe the Canadian Teachers Federation, I don't believe Ms. Yetman has had a chance to talk about specifically what kind of changes that you're looking for in other sections of the criminal code. I know you've sent us material on this.
So our legal counsel has drafted an amendment that would be under 265.5. However, as I said before, I'm a teacher. I'm not a legislator, so I don't know where we go from here. Yesterday, I was doing a little bit of preparing for today, and I noticed that, and it might be something that this committee can look at, New Zealand did an amendment in 2007 on their criminal act, and it was very similar language to Canadian's language. It was a force using correction that was changed to something different. So it was a repeal and an amendment at the same time. And the amendment was about safety of children. So that might be something to look at. That was done in 2007. So our amendment is in our brief, but it's basically to protect the safety of the child or to prevent the child from causing bodily or emotional harm to themselves or to other persons. So there is nothing here about corrective force. It's about protecting the child and making sure that they're safe. And hopefully everybody in the committee has received the document. If not, we'll make sure that you do receive that document.
Thank you very much. We have the documents, Mr. Clerk.
I'll just check if it has been translated.
We're going to confirm that it was received, or we have both the translation of them, because they don't send them out until and unless they're in both official languages. So with that, just want to remind you, if you've heard anything today or you've been asked any questions that you were unable to respond to due to time constraints, we would be happy to receive anything in writing. Unfortunately, our due date is what we've decided is tomorrow at about noontime, because we are going to meet again on Thursday morning to sort of see where the committee comes up with this legislation. So with those words, I thank you again for appearing. Merci beaucoup pour
Thank you very much to our witnesses this morning.
week. Merci beaucoup. We will wait for a minute. We have some witnesses that are appearing in person, and I believe we have one by video conference, so we will do the testing to make sure everything works. Nous sommes de retour. Nous avons parmi nous
Welcome back to our second hour.
and panel. As individuals, we have Dr. Lisa M. Kelly. Is she there? Madame Kelly, can you? Okay, fabulous. Associate Professor, Faculty of Law, Queen's University. Mr. Marc Levasseur, individually, and representing the Nova Scotia Teachers Union, President Ryan Lutz, who actually comes from my Halifax West constituency as well. So welcome to all of you. You have 5 minutes each to present your opening remarks. And again, I think some of you have noticed, I will give a 30-second kind of look, and then because there are 3 witnesses today, I will probably interrupt at the time is up to allow the members on the committee to have sufficient time to also ask questions. And if there's any questions that get posed to you that you don't have sufficient time to respond to, that you'd like to send us a written message back, please do through the clerk's office. So we will begin now with 5 minutes each to Dr. Lisa Kelly, please.
Good afternoon. Thank you for the opportunity to speak with you today. My research and teaching at Queen's University Faculty of Law focuses on how the legal system affects young people as victims and as persons charged with criminal offenses, as well as their families and their teachers. At the outset, as previous witnesses have stated, I wish to state clearly that I share the goals of the sponsors of this bill, that is to end the practice of the physical punishment of children and to promote their best care at home and in schools. That said, the question before Parliament is a specific one about the role of the law, and in particular the criminal law, in this area. And I wish to focus on 3 points in my opening comments. First, the TRC's recommendation. Second, the potential legal effects of repeal for families and children. And third, the demographics of parents and guardians most likely to be affected by repeal. As everyone is aware, the TRC in its 6th call to action recommended repeal of Section 43, and it did so to break with the legal and state systems that facilitated genocidal abuse against Indigenous children in residential schools. In weighing repeal today, it's important to recall that Section 43 is far narrower than it was historically. As you're aware, the Supreme Court of Canada read in significant limitations in 2004. One of the potential impacts of repeal today is that it will contribute to a harsh culture of state intervention, including child removal, to which Indigenous families and children are disproportionately subject. In fact, I would argue that expanding criminal liability for parents may undercut recent initiatives to promote Indigenous sovereignty over child protection, including the 2019 Act respecting First Nations, Inuit, Métis children, youth, and families. And this brings me to my second point, the potential legal effects of repeal. Canada defines assault in Section 265 of the Code very broadly to include any non-consensual physical contact beyond a de minimis level. So how will the situation of repeal change this legal baseline? Let me give you a brief example. Let's suppose a mother is placing a 5-year-old in a car seat and the child keeps kicking at the parent and insisting they want to ride without a car seat. After struggling with the child and receiving several kicks to the chest and the chin, the mother strikes the child twice across the shins and instructs the child not to resist being placed in a car seat now or in the future. What are the potential consequences for the parent and the child if this incident comes to the attention of police, and how might that attention even happen? Well, the parent could be in a high conflict divorce or acrimonious family situation where the other parent will be interested in pursuing this as a criminal matter. Or let's imagine this is a racialized family, a family recently arrived in Canada, or a First Nations family who, for unrelated reasons, is subject to monitoring by child welfare. In a visit from a child welfare worker, the child will be interviewed separately from the mother, this is standard practice, and asked if the parent ever hits the child. The child might then explain that the mother hit their legs a few days ago getting into the car. It's very possible with repeal that at such a point, there would be some involvement by police if child welfare workers and others in authority are aware that Parliament has repealed Section 43 and such an incident constitutes a criminal assault. This brings me to my third and final point. Who is most likely to be subject to punitive intervention? This intervention may take a range of forms. It may mean at least some contact with police, perhaps a warning, but perhaps a charge, perhaps a diversion by the Crown, but perhaps also an assault charge that proceeds and to which the parent may ultimately plead guilty. That's statistically by far the most likely outcome where a charge does proceed. And the parent may ultimately be given a conditional discharge that allows them to avoid a criminal record if they abide by certain conditions, but they may also be given a conditional sentence to be served in the community, but for which they will have a criminal record. I will wrap up now.
Thank you. And you'll have a chance to respond. I think you're probably going to get a lot of questions. So thank you very much.
Thank you.
Monsieur Levasseur, pour 5 minutes, s'il vous plaît.
Merci.
Mr. Levasseur, you have 5 minutes. Thank you very much. My name is Marc Levasseur. I'm a Canadian by birth, descended from Western and Indigenous ancestors from the Algonquin and Mi'kmaq nations. As an adult, I was traditionally adopted by an elder of the Atimakek Nation, and I've been living in relation to the Wemutachi community since then. Among my accomplishments, I hold a master's degree in theological studies with a concentration in Indigenous studies, and I'm in the process of completing a bachelor's degree in social work. I have also worked as a correctional officer with the Correctional Service of Canada, as well as spiritual and social worker within Indigenous communities. Since 2017, I have been on disability due to the trauma I experienced during my childhood. Section 43 has existed for 132 years in the Criminal Code, with the purpose of protecting Western Christian ideological excesses that have for centuries asserted that a child is born tainted by sin and must undergo punishment to atone for their faults. While Western Christianity considers it morally justified to strike children, such a conception did not exist among First Nations. In Atikamekw, a young child is referred to as Awajish, which means the little being of light in reference to its purity. This is why the shock for Indigenous children faced with educational violence in residential schools was so brutal. From its inception to today, this section embodies the colonial legacy of educational violence in Canada. My biological parents told me about the educational violence they endured at school from teachers, and my adoptive mother was forced to attend Indigenous residential schools where she was subjected to the regime of corporal punishment that prevailed in these institutions. This section has a lot of blood on its hands and is an anachronism completely at odds with current culture and educational philosophies promoted in Canada. The legacy of this section dates back to a time when it was legal, enshrined in the Criminal Code, for men to have the right to use force to reasonably beat their wives, and when it was common to sanction adults to various forms of corporal punishment in prisons, including the use of a wooden paddle and a strap. These abuses towards adults have disappeared from practices and laws since the 1960s and 70s, but not for children. Our society has chosen not to give children the same level of protection as adults. It is time to correct this, because even today, despite the provisions of the 2004 Supreme Court ruling, thousands of children here in Canada are growing up in environments that promote educational violence with complete impunity because the content and spirit of Section 43 align with this. For my part, since birth, I have been confronted with a systemic environment of educational violence within evangelical Baptist communities. While some Christian groups have put an end to the excesses of educational violence, evangelical Baptists, like others, continue today to defend these practices and are among those advocating to maintain and strengthen Section 43. In our families and within the church, we were taught that being hit on the buttocks with a wooden paddle or a strap was normal and for our own good. For them, it is a divine mandate, and they believe that one who loves their child must punish them. As a society, we should consider that hitting a child's buttocks as an assault of a psychological, physical, and sexual nature. Yet, this act is considered educational and is still protected under Section 43. I endured these systematic abuses from my parents and church school staff. For various and trivial reasons, such as turning around in class, I received at the ages of 4, 5, and 6 paddle strikes in the church basement. There were about 90 students in this church school. Receiving violence from people from whom I should have received love, security, and kindness led to a rupture of emotional bonds, attachment difficulties, a toxic view of myself, anger, and violence that I had to fight and still fight today. As a young adult, I struggled with substance abuse and homicidal ideations. I have lived with symptoms of complex post-traumatic stress so intense that I have required psychiatric care. I've been in therapy for 10 years now, and I take medication daily. I often wonder what my life could have been without these educational violences and how I could have contributed to our society instead of being a burden on it through the treatments my conditions requires. Mr. Levasseur, I have to interrupt now, but you will have the opportunity to answer all the questions. Thank you very much.
Mr. Lutz, President Lutz, 5 minutes, please.
Thank you, Chair, and thank you for the opportunity to speak today. My name is Ryan Lutz. I'm the president of the Nova Scotia Teachers Union, and we represent approximately 10,000 teachers and educational specialists in Nova Scotia's public school system. And I'd like to acknowledge that I live and work on the unceded territory of the Mi'kmaq people. Teachers are absolutely committed to reconciliation, and we support 100% the Government of Canada's commitment to enact all TRC Commission calls to action. The NSTU is committed to this support while also being committed to keeping our schools and classrooms safe places. As such, the NSTU opposes Bill C-273 if it is passed without other amendments to the Criminal Code. And this is simply because a repeal without amendment will lead to more unsafe classrooms. Student violence against other students, themselves, and educators is on the rise. Now more than ever, we need laws in place to help teachers ensure schools are safe for everyone. It is important that the views of teachers are reflected in your deliberations and decisions. Repealing Section 43 is extremely important, but we have to get it right. Teachers on the ground in the classrooms of our schools, of our country, have not been afforded meaningful consultation, and teachers do not support the bill passing unamended. As the NSTU president, I'm first and foremost a teacher. I'm a high school math teacher, and I can tell you that no teacher wants to physically intervene. No one, like I think Mr. Caputo said, no one gets up in the morning wanting to break students apart. But unfortunately, that need is increasing. I personally have been in situations where I've had to physically intervene to restrain students. And without me being able to do that, there may have been a violent assault in the halls of my school. And again, unfortunately, this is not a unique situation. Numerous situations arise in the school context that require a teacher to respond. These responses might include a teacher placing their hands on a student's shoulder to guide them away from an altercation, or restraining or redirecting a student to protect student safety. Under Section 265 of the Criminal Code, these everyday actions could be subject to prosecution. The repeal of Section 43 would put a chill on teachers trying to do their jobs. It may cause them to stop from ever intervening in difficult situations. And this would compromise the safety of our schools. The unfortunate reality is that 92% of Nova Scotia's teachers have witnessed violence in their schools and classrooms, and 55% have either been the victim of violence or been threatened with violence. A school safety amendment would ensure the specific protection of teachers and educational staff within the criminal code in situations where reasonable physical intervention is necessary to protect the safety and well-being of our students, teachers, and education workers across our country. The Canadian Teachers Federation draft language, which the NSTU supports, seeks to amend Section 265 of the Criminal Code. The amendments would honor the Truth and Reconciliation Commission call to action while also ensuring that teachers can promote safety in our classrooms and schools and protect the safety of a student, which I would remind the committee is the scope of this. The scope of this bill is about protecting students, and that's what teachers, seek to have amendment through this. It's near and dear to our heart to protect students. That's what we all want. It's important to recognize that pursuant to Nova Scotia's Education Act and likely other acts around the province, teachers have the legal duty to protect students, to maintain safe classrooms. And in order to do that, we must have protections in the criminal code that allow us to use reasonable force only when necessary to ensure that our classrooms are safe. Without a school safety amendment, the NSTU anticipates there would be an increase in the number of assault charges filed and prosecuted. The NSTU would have to advise Nova Scotia's teachers, as a precaution, to not physically intervene in situations noted above. This would result in more injuries and more severe injuries to students, and it would result in schools being less safe. And thank you. One of the things that I think has come out here is teachers need to be able to act reasonably without doing a risk-reward analysis of section. We're not lawyers. I need, as a teacher, to be able to grab a student who's running out into the street. I need to be able to pull on someone's hand if they're running towards an altercation. And I need to be doing that without weighing the risk of common law defenses or doing some legal analysis in my head. I need to be able to act reasonably in situations just as a reasonable, loving parent or teacher would. And that's what we're really asking for today. So thank you for having me here, and I look forward to responding to your questions.
Thank you very much. We will now move to our first round of questioning. We will start with 6 minutes each and begin with Mr. Taco Vampopta.
Thank you, Madam Chair, and thank you to all our witnesses, Mr. Lutz, Mr. Levasseur, and Dr. Kelly, for being with us here today and helping us through this very important draft legislation. So, Dr. Kelly, I'll start with you. We're talking about possibly repealing Section 43 of the Criminal Code, which is a codification of the common law defense available for teachers and parents to charges of assault against children. And the Supreme Court of Canada weighed in on this issue 20 years ago, and the Chief Justice at that time said this about Section 43, which they defended as being constitutional. She said, "The reality is that without Section 43, Canada's broad assault law would criminalize force falling far short of what we think of as corporal punishment, like placing an unwilling child in a chair for a 5-minute timeout." So, Dr. Kelly, we heard from earlier witnesses, including the sponsor of this bill, about horrific stories about children being hit in the face, being hit with sticks, physical abuse. So I would like your comment. Does Section 43 protect that kind of behavior?
Thanks for this question. No, it does not. So, as you've alluded to, in 2004, the Supreme Court of Canada read in a series of limitations as to what would constitute reasonable correction when it upheld Section 43. It made clear in that decision that in the case of teachers, corporal punishment of any kind is not included in Section 43, only forms of restraint in cases, for instance, for protecting themselves or other students. And in the case of parents, use of instruments, blows or strikes to the head, contact, physical discipline of children under 2 or teenagers were all read out of the ambit of Section 43. So the only maybe slight caveat I would have to the question is that with respect to, for instance, grabbing a child if they were about to run out onto the street, it's not my view that that would be criminalized if Section 43 were repealed. There would still be necessity defenses in the case of an immediate action to protect a child. But the example that I gave of a strike, for instance, to the leg of a child resisting in a car seat would be within the ambit of 265 and would not be captured. But the more horrendous examples that you gave have indeed been read out. And I have reviewed the case law since Canadian Foundation was decided. And we simply do not see courts today upholding the kinds of egregious abuse that they did prior to 2004.
Thank you for that. If Section 43 were to be repealed, in other words, if this private member's bill does pass through Parliament, in your opinion, would the common law defense kick in again? And what would be the message to the public of repealing Section 43?
So the defenses that would continue to exist and that continue to exist right now alongside Section 43 are those that exist generally for any types of physical contact with anyone, not specific to children. That would include self-defense, force that's used in defense of oneself or a third party in a case of imminent danger. The defense of necessity I referred to when you take an action in an urgent moment, for instance, to prevent someone from running onto a street, those would remain. But outside of that, non-consensual touching beyond a de minimis level, beyond a minimal threshold, would be considered assault. And the message that would be sent, I think proponents of repeal hope that the message will be that all forms of physical discipline are wrong and unlawful. But I think we also have to be attuned to the message that will be sent to police, child welfare workers, and prosecutors, which will be that those forms of my example of striking the child's leg in the car seat, for instance, that all those forms of contact will be assault, and that for particular families, especially those most marginalized, we may indeed see, I would expect to see further cases of that kind that actually go through the system.
Sorry, one quick question. We had witnesses here at our last meeting pointing out that that Parliament never responded to the 2004 decision from the Supreme Court of Canada, that perhaps it is time to expand or to further define this Section 43 defense by basically codifying what the Supreme Court of Canada said. For example, clarifying that force must be sober and reasoned. Force cannot be applied to a child under 2 or over 13, et cetera, right? The items that were listed in the Supreme Court of Canada. What do you say about that? Would that be a good idea to have for example, a Section 43.1 that explains that?
So, we're going to have to wait for the response to another question, just simply to let other members have their turn. Sorry about that. So, Madame Brière.
Thank
for
you,
6
Chair.
minutes.
Yes.
Ms. Brière, you have 6 minutes.
Levasseur, est-ce que vous aimeriez?
Mr. Levasseur, would you like to have an opportunity to finish your opening remarks? Why is it so important for you to be speaking today? Well, I would give you 3 reasons. First, I myself have lived experience. And despite all the efforts I have made to rebuild myself, I have this inside me now. I have this legacy with profound consequences. I've had mental health diagnoses. I take medication on a daily basis just to control the levels of adrenaline and cortisone in my body because it disables me in my daily life. And I'm perfectly intelligent. I'm perfectly capable of making contributions, but I have been disabled. And I don't know how much I'll be able to recover my capacity, my abilities from this. Now, I brought a wooden paddle with me. This is what we were corrected with at the church school. It was shown in court. It is an exact replica. And this is a symbol of what Section 43 was from 1892 up to 2004. Now, I do understand that there was clarification on the part of the Supreme Court in 2004. However, Section 43 was designed for this, for the use of things like this paddle. And this paddle is a symbol that represents that section. Now, since 2004, I do know that limits have been set out by the Supreme Court. But that doesn't change the fact that groups of Christians, for example, evangelical Baptists, who were using paddles like this up until 2004, are now saying, well, you can use your hand. And they actually encourage parents, based on religious grounds, to strike their children if they love them. Now, I think this is an aberration. Whichever good man or woman would have the right to reasonably strike the buttocks of their young 3-year-old girl, for example, 5 or 6 years old. Would an adult do this to someone else without their consent, to another adult? It would be called sexual assault. But a father can strike the bottom of their child, of their girl, with no consequences. And as long as Section 43 is in effect, then these religious groups can continue to promote this kind of punishment based on religious grounds. They can still tell parents in their churches that their parents can slap their children, strike their children. This is a legacy that has had an impact on First Nations as well. It's not part of First Nations culture. You know, children are called a symbol of light. And that is completely at odds with Western Christianity that pointed out that children were born stained by sin. And so adults could strike them. But within Indigenous communities, that didn't exist. That concept didn't exist. Now, I've heard questions asked about the effect that the repeal could have on parents. I just would like to say this. At some point in time, one has to break with cycles, and there has been a cycle of educational violence in Canada. It's been enshrined in our law. At some point in time, that cycle has to stop. We're at a point in our society where less and less parents practice these kinds of things. They're less and less part of our culture. It's less and less accepted. But there's a legacy that goes along with these laws. It's a colonial legacy, and it has to disappear.
Justement, vous entendez les différents...
Thank you. So yes, and in fact, you did hear comments on the part of others and part of other witnesses, and I'm wondering if you've heard the previous testimony as well. And now, Dr. Kelly pointed out that there could be undesirable potential effects of repealing Section 43. For example, let's say a couple that is currently divorcing, and they could use, for example, they could lay criminal charges against the other parent, for example. Well, I would say this. What comes first? So, if corporal punishment were to be stopped, were to be forbidden, then children would become less and less raised in these violent contexts. So there would be less and less punishment perpetuated, corporal punishment. I also think one has to think about child protection services, for example. I've been working in the social work area, and I had a discussion with a professor recently. So he was responsible for assessment within child welfare services, and what he was saying that 80% of children from whom their children were removed didn't necessarily lead to these people have criminal charges being brought against them. However, these children are going to be living with the after effects of the punishment they've received, and no action was taken against these parents. Thank you. Thank you, Mr. Levasseur. We'll now move on for 6 minutes to Mr. Fortin. Thank you very much, Madam Chair, and thank you to all our witnesses today. Mr. Levasseur, I was very moved by your testimony, and please rest assured that for my part, and I think I can speak for everyone, that we completely sympathize with everything that you have experienced in the past. Now, please correct me if I'm wrong. What I understand from your testimony, Mr. Levasseur, is that you are against the use of corporal punishment, and I absolutely agree. You've probably heard other witnesses before yourself who have spoken about teachers or parents who have had to use reasonable force, and they've had to do this, for example, to control a children or two children who are fighting, and they have to separate them. Now, it appears to me that one has to be able to make a distinction between corporal punishment and the use of force that may be necessary at times within these educational contexts by whomever has that authority, whether it be the teacher or parent. So I'd like to hear you on this. Do you think we need to be cautious and be able to separate out these two things, corporal punishment and the use of reasonable force to ensure the safety of children? Well, first, I think that Section 43 has to be repealed because of its legacy, because it represents a correctional force. Now, that's the first point. Second, I'm a parent myself, and I'm also a former correctional officer. My companion is a special ed teacher, so I'm very aware of what can happen. And I'm very aware that one has to sometimes be able to use force. And I'm also aware of what it means to have children. I have discussions with my own companion who at times, yes, has to use a physical force. Now, if there's a need for these things, and personally, I have reservations. However, if there is a need for this, then there has to be a separate section, a separate part of the law. Within the criminal code, there are already provisions for the use of force. For example, when there is imminent danger for oneself or for another, when there's public or disturbing the peace, for example. I've had to use force as a correctional officer. I had to do that when I was working in a hospital context. We had to use physical force to be able to restrain people. No one was ever charged for having to use force. I've had to use it in correctional contexts as well. I had to use it several times. I've had to use it in my personal life. I've had to use it in my civilian life as well. When you see a fight, for example, when someone is assaulting someone, well, I've seen cases like that, and I've had to be able to restrain someone in order to prevent that. I was never charged, and that's because there is legislation that guards against this. Now, in terms of children, let's say that there is a child who understands reality differently from the rest of us. For example, a child who is autistic. And let's say they go into the street, for example. They're posing a danger to themselves. But in that case, someone has the right to use force to protect them. Now, if this child were to take off into a field where they don't represent a danger to anyone else except to themselves, now if someone were to jump on them and use force, well, okay, it may be subject to debate then. Thank you, Mr. Levasseur. I'd like to raise another issue that is a rather delicate one. I appreciate listening to your explanations. You've spoken to how children are perceived within Indigenous communities and that they represent light. Now, we've looked at various pieces of legislation, and what we know is that there is an overrepresentation of various groups in our legal system, in the correctional system as well. And I'm wondering if repealing Section 43 wouldn't have an impact on these overrepresented groups. What would the impact, do you think, be within Indigenous communities? I have a good idea of what you're going to tell me, but I would like to hear you on this, Mr. Levasseur. Thank you. Well, I don't necessarily agree. Is there going to be overrepresentation because of repealing Section 43? Will there be more prevention? Will the line be moved? Will the line be moved between violent use of force or a necessary use of force? I think the line will be much clearer. Thank you very much. I only have about 40 seconds left, so I'm just going to move on to something else. How would repealing Section 43 then lead to any kind of improvement within Indigenous communities? I understand the moral implications of Section 43. I know there's a past attached to that. We don't need necessarily to go back to that. But how would repealing Section 43 actually help Indigenous communities? Well, beyond the legacy, it would help just draw that line. It would break with these cycles of violence that have been perpetuated through education in Canada and that can still be perpetuated because it's still allowed. There's a very large gray zone. Thank you. Thank you very much.
Mr. Garrison, please.
Thank you very much, Madam Chair. I want to start by thanking Mr. Levasseur for bringing his very powerful personal testimony. And I think as parliamentarians, we don't often credit the bravery and the difficulty for people to do that. So I thank you very personally. But I think you've done something else very important in addition to that, and that is you've taken us back to the kind of first causes. So why did we ever decide that violence against children was acceptable as non-Indigenous Canadians? And I'd like you to say a bit more about that difference that you talked about in your opening statement that causes us to say, even today, you can't use force against adults, but with children, it's somehow okay.
Do you mean specifically in Indigenous context?
Well, the contrast between non-Indigenous and Indigenous approaches to that question.
Okay. Ben, c'est le contraste en réalité.
Well, if you go back through colonial history, Christianity, those who are familiar with Augustinian principles, children are born tainted by sin. So they're already seen as bad within that approach, that perspective. I've looked at the various scriptures, and so there's this belief, and it's actually spelled out, that a rod will spare them from this. Well, we'll correct that tainting. And that view dates right back to the Middle Ages. And through the church, it has been perpetuated through colonialism. Indigenous communities and groups did not have that same vision of education. They did not have that same view of children. The Western view has a very hierarchical approach. There's the father, the woman was below the man, and then there were the children. And they were actually seen as belonging or the possessions of the parents. But within Indigenous communities, you have a circle, not a triangle. And the child is seen as awashish, and they are a symbol of light. And that represents also the energy of the Creator. So they were not only the symbol of purity, but at birth they were actually a miracle of life. They were literally a reflection of the Creator coming into this world without necessarily being the Creator. Let's be clear. I don't necessarily want to sound like what the Christians used to sound like, but they were seen as being pure. They weren't seen as property. And what did residential schools do? Well, they took these children, and their perspective of the world was very, very different. There was good and bad, and these children were told that their parents were heathens, that they were heathens. Corporal punishment was used to rid them of evil. And that was a huge shock. It was a shock that they felt that became part of them. And so this vision was imposed on them. And these children really were subject to this vision of the world, and then they returned to their communities with that violence in them.
With the little time I have left, to Ms. Kelly and her concern, her third concern she raised about the impacts on marginalized people of repealing this section. I'm not quite sure that I understood your concern there. So, Dr. Kelly, can you maybe go through that again with me?
Sure, absolutely. So we know that in both the child welfare and the criminal legal system in Canada, that Indigenous peoples, racialized people, especially Black people, and poorer and working class people are overrepresented and they're over-surveilled as compared to their more affluent, whiter counterparts. A concern is that not that if Section 43 is repealed, that in the morning we will see swaths of parents being arrested across the country, but that those who are already within and more heavily surveilled systems will have these types of incidents come to the attention of state authorities and worked through at some level the criminal legal system. And that there will be gendered and racial and class elements. For instance, we know that in Ontario, of cases of child maltreatment that have been found to have been verified as of 2018, that 86% of those cases involve biological mothers, 90% of them involve female carers. And we also know that uses of physical discipline or non-consensual touch are more likely to occur in homes where there is greater economic stress, in single-parented households, et cetera. And so I believe that what we will likely see is a continuation of these forms of inequality. I think it's important to note, yes, this defense is a colonial one, but the entire criminal code is a colonial construct that was imposed in the late 19th century, and it's that part of the system that will be aimed at this kind of contact.
Thank you, Dr. Kelly. We will now move to our second round with Mr. Moore for 5 minutes, please.
Thank you, Madam Chair, and Mr. Lavisser and Mr. Lutz and Dr. Kelly. You've all had fantastic testimony today. This is a great panel that I'm sure we could go on because you've all had so much to offer on this discussion. So we really do appreciate it. And you know, you look at Section 43, we can look at it in the historical context, but we also, as we sit here today, have to look at it in the reality of what the law does and what the law does not do here in 2024. And we are dealing at Section 43 now, not as it is written in the code, but also as it has been significantly interpreted and narrowed in a leading Supreme Court of Canada case, a case that had it not existed, Parliament itself may have taken similar action. So I know when the bill was introduced, Dr. Kelly, I'll address this to you. When the bill was introduced, the proponent mentioned in their opening remarks some actions that clearly, my view is that they fall outside of the scope of Section 43. And but I want to get your opinion on it. For example, punching or slapping a child in the face. Do you think that is that there's a defense in Section 43 for that, as interpreted by the Supreme Court?
No, I do not.
And paddling a child or striking a child with an object?
No, I do not.
Okay. And leaving a bruise, slapping someone and leaving a bruise on their cheek,
No.
Section 43, no. So, and we also know that the court narrowed the application of Section 43 for corrective to those that are 2 and over and not yet teenagers. What about teachers administering corporal punishment? Does Section 43, as interpreted by the Supreme Court in this leading decision, Section 43 then, as it appears before us in Canadian law, can teachers administer corporal punishment and be protected by Section 43?
No, they cannot.
Okay, and thank you for your quick answers, because I think that's the reality that we're dealing with here today. There was a reality before, but then there's the reality in the law, and that's what, with this private members bill, we are vested with today. And I think I've seen some of the dangers that have been highlighted with just simply abolishing Section 43. Mr. Lutz, you mentioned, and we heard previous testimony on this, the chilling effect it could have on teachers when it comes to breaking up a fight. And I, as a parent, I find that remark kind of horrifying when you think if someone is being beaten by a school classmate or by a couple classmates, and you only have to look on your social media, this is happening all over. It's being posted. I know you're from Nova Scotia. I'm from New Brunswick. We're seeing this across the country and internationally. Video of fights at school. It's not an easy environment that teachers are in. Can you speak to a bit this chilling effect that you, as a leader, would be the message you would be sending to your teachers if this protection is not there?
Yeah, absolutely, and thanks for the question. And first off, I want to say, the NSTU opposes violence against children. Period. Full stop. And corporal punishment as well. That is not what we're speaking to. I also agree with the Monsieur Lavasseur that I think it's really important to repeal Section 43. It's just important to get it right. So I appreciate the colonial legacy that Section 43 has brought to us. We have to do away with that. Section 43 should be repealed, but it should be done so while at the same time protecting teachers in schools. And the unfortunate reality is that our schools are more violent than they were, and that's not a reality that I want. I have 2 kids. That's not the reality I want for them. I also want their teachers able to protect them and keep them safe. And I want them to be able to do that without doing a mental calculus of, do they think that the criminal law is going to protect them or not? So I think we can do both. I think we can repeal Section 43 and honor the Truth and Reconciliation Commission while also amending the criminal code to make teachers able to keep their kids safe at school. That's what we want. And at the end of the day, it's, again, parliamentary procedure is not my expertise. I'm a math teacher. That's where we look to you. But if we can't get this right, I think that's where we have to put our efforts. We have to put our efforts into doing both things at once. And I believe this committee and the esteemed folks around this table can do that, can repeal Section 43 while also ensuring that teachers and schools have the tools they need to keep our kids safe. So I would just implore that the folks around this table go back and do both of those things. But to do one of them without taking into account the other, I think, would put our teachers and our schools at risk.
Thank you, Mr. Lutz. We will now pass to Mr. Maloney, please, for 5 minutes.
Thank you, Chair. I want to agree with what Mr. Moore just said. This panel has been very informative, as all the panels have been on this issue, frankly. And I'm glad, I think Mr. Moore used the term a dose of reality or being realistic, because this is the part I'm struggling with. I mean, we can all give examples around this table of extreme cases where a change would not work or would work, or if the status quo doesn't work. So we need to sort of parse that out and get to the core of the issue. So, Mr. Lutz, for you, sir, to start with, the Nova Scotia Teachers falls under the jurisdiction of the Canadian Teachers Federation, I'm assuming?
We are a member of the Canadian Teachers Federation.
Okay, because Ms. Yetman said in her testimony earlier today, and I think you were here, that if Section 43 is repealed, that it would be their advice to teachers not to touch or lay a hand on any students. Do you agree with that approach if that's what happens?
So that is what our legal experts are saying, is that would have to be, that's not a world I want to live in, but that would have to be our advice for teachers moving forward.
Okay, so I want to pick up on something more just said. Let's assume this is a grade 7 class. You're the teacher, and Mr. Caputo and Mr. Moore start to beat me up. If Section 43 is repealed, are you going to tell your teachers that they have to stand by and watch that happen and not inject themselves and to try to break up the fight?
I mean, again, I certainly hope not. What are legal?
Well, no, it's not hope. This is a very realistic question.
Yeah,
because the evidence is that they will tell their teachers not to touch their students. I'm giving you a real scenario. It happens in classrooms all the time.
Absolutely.
So what would you do as a math teacher in a grade 7 class if those two guys start beating me up?
So let's just be clear. What our legal experts are saying is that our advice would have to be not to lay your hands on kids, period. What I would do as a math, if I can finish my question, do you mind if I finish the question? Because I think it's really important. What I would do as a teacher in that class is I would intervene. I would find someone to intervene. But I don't want our teachers to have to go through some nuanced legal analysis. I want them to be able to take really reasonable reactions in the moment to keep kids safe. And that's where our legal experts have said, without Section 43, we would be putting teachers at risk. And I don't want to live in that world. I want to live in the world where the teachers can intervene reasonably to keep kids safe and know they're protected. And that's what I really want to be clear, because our position is very nuanced. It is Section 43 should be repealed, while at the exact same time additional protection should be given so that teachers and schools have the tools in their toolbox to keep kids safe. We shouldn't be doing one without the other. Section 43 should be repealed, and at the same time, and it's really important that it happens at the same time, we must include the school safety amendment to ensure that teachers are not prosecuted for, again, very reasonable interventions to keep kids safe.
I don't disagree with you, Mr. Lutz. Unfortunately, I think perhaps the position might be over-nuanced and over-legally analyzed, to be honest, because I don't think there's a scenario where the example I just gave, where a court's going to hold you responsible for breaking up a fight and protecting one student from two other students or one other student. And I don't think the repeal of Section 43 would create that exposure. So I think you would still be allowed to do your job in the same way we are now. Section 43, as we've heard time and time again, was introduced at a time and place that is entirely different now. And it's entirely different than it was prior to the Supreme Court of Canada decision as well. So I want to move over to you, Dr. Kelly. Let's assume that Section 43 is repealed, and let's assume that a student or a teacher rather is charged with an offense, as they could be now, because I don't think students or teachers or parents know that Section 43 exists until they hire a lawyer in a particular situation. Do you not think that the Supreme Court of Canada, as they've laid out in their decision, that would still provide guidance to courts in analyzing a particular set of facts when a teacher's put in a position where he has to defend himself against an assault charge?
Yes, absolutely. If a teacher, if anyone is charged with an assault and there is a need to apply or to interpret Section 43, a court does so in accordance with
I'm saying in the absence of Section 43, that would still provide guidelines to judges who are reviewing the facts of a case against a teacher.
Well, in the absence of Section 43, then you would be interpreting the contact as you would under general Section 265 assault jurisprudence.
Are you saying that Supreme Court case would have no bearing whatsoever? Is that your position?
That's correct.
We will now move to our last two questions at 2.5 minutes, please, to Monsieur Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. Ms. Kelly, I'd like to continue with you for these next couple of minutes. From what I've understood from the various testimonies is that corporal punishment must be forbidden and must not be allowed under Section 43, even though with the interpretation of the Supreme Court it's already forbidden. But there's an amendment, there could be an amendment that would forbid this type of corporal punishment. So one could forbid corporal punishment, but at the same time, there could be allowance for the use of reasonable force for the safety of children. Would that not work?
Would be for an amended Section 43 or a new provision, if 43 were repealed, as one of the earlier members questioned, to actually codify the limits and the narrowing that the Supreme Court undertook in 2004 as a rewritten provision, such that anyone who picked up the code would be aware of the limits as they exist right now. Is that the question? So that could absolutely be done as an amendment to Section 43, or perhaps as a new defense.
Merci. Oui, il me reste que...
Thank you very much. And I only have a few seconds left. So, Ms. Kelly, yes, you understood the question. Thank you. But beyond the whole legal aspect, that is to say whether it should be codified or not, I'd like you also to speak to the substance of this. Do you think, in the light of your expertise, that it would be a good idea to allow the use of reasonable force for the safety of children in these educational contexts, avoiding corporal punishment?
Yes, I think that in some of the situations that have been raised in an educational setting or otherwise, there may need to be instances where, for the protection of students, a teacher will want to intervene. And it may be an intervention that wouldn't be fully captured by or excused by the current law of self-defense. I think there are some unique considerations with respect to young people that don't always apply, for instance, to adult-adult relationships.
Merci beaucoup.
Yes. Merci beaucoup.
Thank you very much.
It's to Mr. Garrison, please.
Thank you very much, Madam Chair. And this is the only advantage of being the fourth party, is quite often I get the last question. I just want to say thank you to the Teachers Federations for assigning us homework as members of parliaments to go along with this private members bill, because I do think they raised important points and concerns. But I want to end with a question to Mr. Levasseur, who was very eloquent on both the historic harms and the current harms of the existence of this. And Mr. Levasseur, I wonder if you could talk a bit about what you think the impacts of repealing this section would have in terms of reconciliation and breaking the cycle of violence in families.
Sorry, I'm just sorting my thoughts out in French. First of all, repealing this section sends a message that this was wrong. For years, even myself in my personal life have known Section 43, have been aware of it. And most of the people don't know about this provision. Even within the social work setting, people are surprised that Section 43 still exists. But I myself, since I've been very young, have been familiar with Section 43. Why? Well, because that's what gave the right to my parents and to the educators to use corporal punishment on me. We've heard that since 2004, corporal punishment has been forbidden. Well, that's not exactly true. It's restricted, but it hasn't been forbidden. So the Canadian legislation still has not said that corporal punishment is absolutely forbidden. Under Canadian legislation, physical punishment is allowed in a narrower context. But a father can still reasonably strike the bottom of their little girl. It's still allowed under Section 43. So sending a message that this is not right is important, because all these children who were in residential schools who were subject to this kind of abuse need to see that it was not right Thank you very much.
In the second panel, you have certainly given us a lot of homework and a lot of things to think about over the next few hours. So thank you very much for those that have come in person, and thank you very much, Dr. Kelly, for sharing your legal expertise with us. And with those few words, I think, was there anything on a business? No, I think we will conclude and we will see everybody Thursday morning. Thank you very much.
See?